our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody, and welcome to the show. Today, our topic is property ownership, protecting yourself from squatters. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel. You can find us on Facebook, X, and on YouTube. On all of those platforms, you can find us at the handle @InRem Podcast. That's @InRem Podcast. Go there, like, subscribe. We'd really appreciate it. Also, if you want to listen to an audio version of the podcast, you can go to Spotify or Apple Podcasts or any other major podcast platform. Download a version, like, subscribe, listen away. We appreciate it. It helps us out a ton. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is, what is a quitclaim deed and when should it be used? So a quitclaim deed is a method of basically conveying whatever rights a person has in real estate to a third party. It's not the most effective method or means of conveying real estate. And the reason is because there's no warranties that come with that. There's no, I'm the fee simple owner. I'm the owner of the property, and I'm going to convey this property and warrant my conveyance of this property and entitled to the property to this third party. That's not what a quitclaim deed is. A quitclaim deed is basically saying, hey, I'm not representing that I even have any ownership in this property. But to the extent I happen to have some ownership, you can have it without any representations or warranties of title. Title companies do not like quitclaim deeds. They generally are going to require additional documents, affidavits, maybe even a warranty deed from the person or the grantor under the quitclaim deed to the grantee to fix it and make sure that they're comfortable with title being held and whoever it was being conveyed to. But a quitclaim deed can prove useful in certain circumstances. One circumstance in particular is when there is a question as to ownership of property. And there's this thing called quiet title, which means that one property owner could feel like the title to their property is being threatened by somebody else. And so they want to quiet the title. They want the court to determine that they are the owner of that property with a greater right to it than whoever this third party is that may be claiming or perceived to claim some right, title, or interest in their property. In Arizona, before you go and file your quiet title action, if you want to recover your attorney's fees, you have to send a quitclaim deed to this third party and basically explain, hey, I'm getting ready to file a quiet title action against you, but in lieu of me doing that, why don't you execute a quitclaim deed? So whatever interest you may have in this property, execute this quitclaim deed saying you're giving it to me. You're basically releasing any interest in the property that you have in my favor. And if you execute this, then there's no need for the quiet title action. So that's an example of where it's used. It's basically going to be used for somebody to just release their interest in the property. They don't want to warrant that they even have an interest. They just want to release it. They just want to say, okay, I'm done. I don't want to have anything to do with this property. I'm just going to quitclaim it over to this third party. But it's not a warranty of title. does have some issues later on potentially with title to the property and title companies closing future transactions where quit claim deeds were used. But nevertheless, it is a good document and means for somebody to simply just give up whatever they think they have or may have with respect to a piece of property.
All right. Thank you, Sean, for the legal update. Reminder, every Tuesday at 2 p.m. Arizona time, we have the Creative Finance Collective. The Creative Finance Collective is a time for lawyers or professionals in the space of creative finance to come and talk about creative financing. And those lawyers, we've got lawyers that come from it from Arizona, Wisconsin, Florida, Texas, Alabama, Georgia, Ohio. We've had them from all over the place. But if you've been in the creative finance space for a while, you might find that there's not that many attorneys that really have a substantive knowledge of what it takes to do and manage the creative finance transaction properly. So the Creative Finance Collective is an opportunity for those that are in the space to get together and talk through issues that we're seeing, the good, the bad, the ugly, so on and so forth. But what it's also is it's a opportunity for you, the listener, to engage with us, ask any questions that you have, and we can we're there to answer those questions, to go through any issues, direct you possibly to referrals of other attorneys in your state that might be able to help you. But we're really there to have a conversation about creative finance. And we're on as long as we're getting questions. So it's important for you to engage and be there. You can find that on YouTube, X, and Facebook at the NREM Podcast, at NREM Podcast. You can go there. It's live, 2 p.m. Arizona time every Tuesday. Make sure to join us. All right, we're going to get into our topic today. We're talking about real estate as usual, but we're talking about squatters. That's been a topic of conversation in the past year. There's been laws that have been passed throughout the country relating to that, but we wanted to talk and devote an entire episode to that issue and what property owners face and the process moving forward that they face, at least with respect to the state here in Arizona. And with us to discuss that is attorney Denise Holliday. Denise, thanks so much for joining us.
Hey, thanks for inviting me. I really appreciate it.
Yeah, we really appreciate having you. So give our listeners an idea. Tell us about your background, how you got into doing what you do, what led you to that.
Craziness, and craziness. No, just joking. So I'm a business major, worked in both business but also in the educational arena for a while. When moved over, joined Andy Hull. He was known as Dr. Victor, had been around since 70s. Worked with him for a long time, and now we are a partnership. So our firm focuses all of our practice on representing landlords. So we don't represent any tenants. We do residential, we do commercial, RV parks, mobile home parks. We do fair housing. We do civil cases. We call them post-possession civil cases. So when the person's no longer there, we do those civil cases too. So that's really what we do, and I've been doing it for over 30 years. Love it, and enjoy the entire field.
Denise, I remember early on after I passed the bar, must have been within the first year or so, I was licensed and I was taking some of my first CLEs, and I was working for a real estate firm. So they were going to, of course, have the new lawyer do landlord tenant. But one of my first instructors in the CLE course was Andy Hall. I remember to this day. I remember the Dr. Victor website. Does the Dr. Victor website, is it still up?
It is. It's the word doctor spelled so DoctorEvictor.com. It's still there. What happened was several unseemly people took that name and played bad things with it. And so also the Attorney General's office was like, that's kind of mean. Like, it's what we do. So if you go there, if you type it in, it directs it to the same website. We also now advertise it as the letter H3 landlord law. Both of those take you to the exact same website. So we're still here. The pun on it was Doc Holliday. That's my husband's family. So we thought it was funny and witty, and apparently people think it's politically incorrect, but it's what we do.
Well, I know of what you all do and what you're capable of. And for as long as I've been an attorney, this has been the go-to place for evictions. Now, I understand you serve as a judge pro tem. Tell us about that and what court.
So I'm a pro tem judge. I sit in all the justice courts in Maricopa County. I also sit in the Superior Court. A pro tem judge is one that's brought in because the judge is conflicted out. There's some reason the judge can't hear that case or doesn't want to hear that case, or they're on vacation or for whatever. So I'm a pro tem for both of the county courts on the justice side and on the Superior Court side. So I hear everything from breach of contract, I hear criminal cases, traffic, orders of protection, really the whole gamut between the two courts. Learn all kinds of amazing things that I didn't even know were the law. Kind of amazing.
Very cool. So we're talking about squatters today, and that term by itself carries a load of baggage. And now we're lawyers, so words are terms of art. Typically, they mean something, and maybe given our country, it might mean 50 might have 50 different definitions depending on the state that you're in. But let's lay some groundwork for the listeners just to start here. How would you define a squatter as a landlord-tenant attorney? When you hear that term, what does that mean to you?
And let me tell you, there's no definition in Arizona. The legislature tried to create a statute that specifically said what a squatter is and what a squatter is not, and the governor vetoed it. I expect that bill to come back again because we're still having a huge problem, and those people who are in those properties illegally should not be protected under some of the statutes that were just not designed for them. So what I say as a squatter is any person who's in the property without permission of the landlord and they entered illegally. So it is not Uncle Buck that comes and stays for too long after a vacation. It is not your girlfriend that you broke up and you don't want her to stay there anymore. It is not your son who won't get a job and won't move out. It's not the tenant who had a lease and then now won't leave. All of those other relationships are governed by other statutes. And so to me, that was what the governor was afraid of, is that the squatter statute would now somehow envelop other sets of circumstances. That's not what I think. I think just like vacation rentals aren't really governed by regular landlord-tenant laws, we probably need a vacation rental act so that everybody who's going to invest knows the playing field. Not if it's in Scottsdale or Phoenix, but like in the state, these are the laws. The squatter bill really would be a definition of somebody who, without the landlord's knowledge or consent, enters into their property illegally and sets up some kind of household. So it wouldn't be for commercial. It's just going to be a residential situation, probably.
So just to clarify and break this down. So, a holdover tenant, one that stays in after the expiration of the lease, that in your mind isn't a squatter. A relative who you allowed to stay there, a friend of one of your children that, is couch surfing, wouldn't be a squatter if you've basically let them live there. But we're talking about somebody, who basically entered illegally through some means of a trespass, if you will. But what about, and I know these stories happen, what about somebody who entered believing they were lawfully entering? And what I mean by that is there are scam artists out there that post stuff on Craigslist for vacant property saying, oh, I own it, I'm the landlord. And they go and they actually do everything, negotiate a lease, give the purported tenant a lease, open the door for them, let them move in, only for the real owner to come back and be like, that's not my lease. I didn't sign that you got scammed. Well, the tenant actually thought they were entering legally. They weren't trying to trespass. Would they be considered a squatter?
And that's the question. We don't know. I think that
Okay.
Title 12 would resolve that, because Title 12 says if you forcefully enter the property or enter into the property and remain when the owner says you don't have the right to be there. So I think Title 12 would already deal with that situation. I think you still have to give them a notice saying that that contract was illegal. They bought a stolen car, and they should call the police. They should take those steps. And I can tell you that we worry that as more and more homes become for rent off of Zillow and other social medias, that will continue to happen more and more, because the tenant, one who's, I call them the applicant because they're not a tenant yet, the applicant doesn't know what to do to protect themselves. And there's some really simple things they could do, like just look at the deed and see if the deed is not in the name of the person who's renting to you. Ask to see a copy of like the property management agreement, and then do some research. We just had a really good fake case, one of the best ones I've ever seen, where the advertisement had actually copied a social media advertisement. It was for sale or for rent by an owner, so not through a property management company. They just copied it. They were out of Russia. They just typically copied it, reduced the rent by $400. So of course, the first person who saw that, like, oh, I remember seeing that ad. Yeah, I even saw reviews on that guy, and did everything right. They produced a lease. They said, look, you can check my ad. They just spoofed the whole entire ad. So that one would have been harder to catch, but they need to call the police right away. They unfortunately they bought a stolen car, so they're not going to be able to stay. There are some landlords who may work with them if you can prove that you really were scammed and you're doing all of the things necessary to convince that landlord. They might rent that house to you. You're going to have to pay deposits and sign a new lease. But if you are really a truly scammed person, I can tell you lots of my clients will have heard that, especially on the big corporate rentals, that property sat empty. So there's, it's easier to get scammed maybe. And so they're more willing to say, send me an app, fill out an application, send me money. Let's try to keep you in place while you pursue the stolen monies.
So you had mentioned Title 12. Andy and I understand what Title 12 is, but can you explain to our audience what is Title 12 when you refer to that?
Thank you. Yeah. So Title 12 is what we call like the grandfathered landlord tenant law. It's very, very basic, explains what's called a forcible detainer or an forcible entry. And those are old words. We call them evictions now. And that's the basic of explaining to the court system what happens, what's the relationship. Then the court went and created Title 33, which are more property relevant laws. There's a base Title 33, we call that the commercial statutes or the general statutes. And that's for everything that's not covered by a special statute. That's why we call those special detainers. So the special statutes are the Residential Landlord Tenant Act, the Mobile Home Park Act, and the long-term RV Park Act. So those are what we call special detainers. They're all called evictions. Those are just some really old words. But Title 33 is where all of the relationships are specified. So we'll put on my judge hat for a second. So a person comes to me and they say, okay, I want to do an eviction. I'm going to first try to figure out what's the relationship. So is there a lease? Was there an oral contract? Did you take any money? Are they paying for the right to live there? Where is the property located? Do you own what's underneath it and what's on top? Because a mobile home, maybe you don't own underneath, but maybe you do. Maybe it's in the middle of a forest. Maybe it's in your back 40, whatever. So as a judge, I'm going to break it into those categories to see what law applies to you. And there's a whole lot of different laws that may apply, which is why at the very beginning of our conversation, I said, I think we need some clarification of what a trespass looks like to take it out of these other general laws and put it into this other really more heinous person who's really forcibly gone into the property, squatted, said, I'm not leaving. I wasn't scammed. It was like I don't care. I'm not leaving till you make me. That's to me what a real squatter is.
So to follow up on some of this and your definition, Denise, of a squatter, always in the media, things are sensationalized, right? We get a sense that there is this massive problem and everybody, and sometimes you get a slew of legislation attempting to deal with it, but nobody really interviews or talks with the boots on the ground, the people that actually are dealing with this. And I think when you talk in terms of people that are actually dealing with this, you would be a perfect example of that. An attorney on the ground doing landlord-tenant work, seeing the evictions, seeing when the landlord-tenant relationship goes south. What is your sense? Is squatting, by your definition, not all the other issues, but the sense that there are trespassers coming and basically taking over, for lack of a better term, property and living there. Is that a problem? Are you actually seeing those cases?
I'm so glad you said that. I've had multiple local and national TV stations call, and I give the interview, and the story never plays. or just their version of the story plays, because it's not, our laws in Arizona are very landlord friendly. We want tenants to have good, solid opportunities to rent, but we also want to make sure that we bring lots of people here to invest in our properties. So it really is a good balance. In Arizona, the stories that you see all over all over the country, those just don't exist. They just don't. If you have somebody that's in your property illegally, there's a much faster way to get them out, a very short period of time to get them out. So it's not very sensational like it is around. You hear the person in California who bought a house and they haven't lived there now in 2 years, and they still have to pay the mortgage. That just simply doesn't happen here. Like I said, we do a couple thousand evictions a month. We've been doing them for 45 years. So we really are one of the biggest law firms, major law firms. And I'm the president of ALTA, which are the landlord tenant attorneys. So we talk all the time. What are you seeing? During the pandemic, we saw more of that. That was really caused because we had vacant homes, and we had some governmental authorities that were stopping people from being moved. And so it was easier for people, especially from other states, feels like other countries like California, other states coming here and just seeing a for sale sign and just moving in. And we have quite a few large conglomerates, I'll call them, that own large portfolios of single family homes. And I think they saw an uptick because they didn't have as many people be able to walk around and check the properties for occupancy. They changed their way of business, took down the signs. There really are no for rent signs anymore, because that's just a, hey, come break into me sign. They started putting signs on the inside of the property so that it says stop. If you are renting this online and this is not the code that you got, or this is not the person renting, this is not the landlord. They also put them inside the house in strategic areas, because the bad guys, the scammers, aren't actually going into the house and not looking to take down the sign that says, don't rent from anybody but Bob. But it's just not as big a deal here, I think, as long as you're staying on top. So the people who go off on vacation and come home, we don't see hardly any of those. The ones that we see maybe a little more are the people who have second homes. So in some of the more recreational areas, they may have a second home. But the people who have even a second home, like in a condo association or gated community, they're just not seeing those issues. It's really truly a vacant home where the neighbors don't see you very often. And so they don't really know who's coming and going. And now people have vacation rentals. So the Mrs. Kravitz who lived next door, she's not going to say, hey, I see people at your house, because she doesn't even know who's supposed to be coming and going. So I would say start a great relationship with your neighbors if you have a second home. Or if you rent it as a vacation rental, so that someone's telling you, hey, I see there's lights on over at the house. I see there's cars over at the house. Are somebody supposed to be here? Because the longer they stay, sometimes they're smart. They even put the utilities in their name, which is kind of odd because the utilities are already on, but they make up a fake lease. They take it, put the utilities on in their name, like, see, I'm supposed to be here. Somebody named Bob came by and gave me this lease. And lots of times they are active participants in the same scam. We see them in multiple properties. As they get evicted, they just move to another one because we never really know their name. So nobody's not able to check the eviction records to see, except for constables who recognize their face sometimes.
What about homes that are subject to probate? I mean, those tend to be vacant. It may take a while to, get those homes in shape to deal with whatever court proceedings need to be dealt with. Do you see situations where, probate, what I would call probate homes or estate-owned homes, are subject to, squatters?
Yeah, I can tell you, though, my experience is, because we work with probate attorneys, they send me their cases. Lots of other attorneys, including your firm, when there's certain kind of more unique scenarios, they'll send it to us because it may be the first time they've seen it in 30 years, but I've seen 10 this month. So it's just a numbers game. And so that's not usually who the squatter is. It's usually a family member who could be like a cousin or a third cousin. Somebody knows that Uncle John and Aunt Mary passed away. And so they're the ones who take over that house. So most of our probate cases are not just that, what I call third party tortfeasor, just some random person who moves in. It's typically someone that knows the scenario, knows the family, a very close family friend or a family member. And those, like I said, can be handled under the existing laws as a true person who's not allowed to be here. But that's probably not the same as the true squatter scenario.
Yeah. Well, let's talk, say I have a vacation home and I come back for my winter in the desert and I'm, ready to move in, and I show up and all of a sudden I realize there's people living in this vacation home. What would your recommendation be as far as the first steps that somebody would take if they discover this scenario?
That's a great question, by the way. I tell everybody, let's back up just a tad. Let's put an alarm system on. You can put an alarm on your water account and your electricity account that says if it goes over this amount, that utility company will tell me. Suddenly my little tiny $100 bill goes into $300, or my $20 a month for whatever now is much larger. I have a leak or somebody's staying there. So there's some things you can do besides just talking to your neighbors that would prevent that. Alarm systems are amazing because they're even portable now. So it's real simple to have that, that going. So that's the first part. But when you get there and you come up and you see somebody there, don't confront them. There's some violence that happens depending on who those people are, especially in our more rural areas where our cabins are. Some of the cabins are pretty far away from other people. So be careful. We've seen some violence there. So when you pull up and you see a car, don't go up and knock on the door. Don't use your key. That can be an immediate sense of violence. So don't do that. Back out, go down the street a little bit, call the police. Typically, if it's in more of a rural area, it's going to be the sheriff's department. And I'm just going to tell you, depending on the city or the county, you may have law enforcement that goes out there and goes, "Who are you? Get out or I'm arresting you. You are a criminal trespasser. Show me your driver's license. That's it. Move right now." And that didn't happen 5 years ago because we didn't have the squatter situation. Now they kind of know this is what's happening, especially during the pandemic. They were more familiar with, let's look, you got California license plates, or another state where we know maybe they've got some much different rules than we have. And they've been watching this on TV and I think it's great. So our law enforcement is really your first step. However, that being said, we're going to have some law enforcement, especially in the Valley, who are going to say, look, it's a civil matter. I can't do anything about it. It's too bad. Sorry. Please do not take any of this matters in your own hand. I know that there's a couple of very creative businesses that have been made where the homeowner hires this company to truly rent to maybe some obnoxious people who are intentionally obnoxious, and they come right into the house and they walk around naked and they move in they have all their loud furniture, their story, and their party, and the bad guys just move. I've actually talked and interviewed with several of them because I think it's an interesting concept. And just as a human being, you're like, yeah, fine. This is a real life lease. What are they going to do? Call the police? Police will go, remember, trespasser? It's a civil matter. You have to go evict them. And they just get really obnoxious, leaving doors open and all that kind of stuff.
Right.
There is a risk there. There is a risk that you're going to just escalate that scenario. And to me, what's going to happen to the home in the meanwhile? And will your insurance cover somebody being injured, God forbid, because you put them into that scenario? So I wouldn't move back in myself. I wouldn't have my cousin John, who is a tactical warrior, who's going to come and save me. I would leave it to the police, but that's me. I'm a lawyer and a judge, and so I'm going to handle it legally. So do a police report. You need some kind of law enforcement report that says, because they're just going to talk, and there's a legal principle that when you say something, this excited utterance that just comes out of your mouth, it's typically more often than not more truthful than if you have a month to prepare or 2 weeks to prepare for trial, and what you're going to tell the judge now. And so that police report is very, very helpful in the eviction side. And then you need to get a hold of an eviction attorney. We know that they'll talk to a realtor and some friends and Google some stuff on TV, or on the radio or the computer, and all this stuff. You've now wasted weeks and weeks and weeks. And the longer they're there, that whole possession's 9/10 of the law, that really becomes an issue, because the longer they're there, they put kids into school, and all the neighbors, they throw barbecues for all the neighbors to say, no, we love them. They're great. These are great people. So it's really getting on top of it right away. If you when in doubt, you don't know what to do, call law enforcement and give a notice, a written demand notice saying you need to move. The statute says if you get a demand to vacate and you don't, 5 days later you can go to court. So there's no magic words. We have one on our website. Our website's free for everyone, by the way, because we want you to know of those notices. But you need to say, get out. You don't have the right to be here. If you don't leave, I'm gonna file an eviction.
Yeah, so Denise, let's break that down a little bit, because one thing I've learned about landlord-tenant law in Arizona is it, like you mentioned before, it's fast, it's effective, it's efficient, it gets the job done. But what I've learned, and I'm sure anybody who's been through the process has learned, that judges expect that if we're going to give you this fast procedure, we're going to expect you to follow the requirements to a T.
To a T.
To a T. That notice needs to be the right notice. It can't be the wrong notice. It needs to be served the way that the statute wants it to be served. You know, there is no, you know, oh, whoops, I slightly did this wrong. A judge is not afraid to bounce that case and force you to start all over. And if you're dealing with squatters, you know, a week feels like an eternity, right? So one, I don't think, and I think, Denise, you emphasize this, but we can't emphasize enough. You got to get somebody who knows what they're doing on this right away, preferably, really, certainly a landlord-tenant attorney. But it really starts with the notice, right? Using the correct one and serving it correctly. What does that typically look like?
So we have a sample one on our website, and it basically has to say something like a trespass notice or notice to vacate, as we call them. It has to be a demand for you to get out. And so it has to have a date. It has to have, if you don't know who they are, we say Jane and John Doe, or somebody who calls himself Bob Doe. We don't know what their last name is. So it has to have a date. It has to have a name, at least Jane and John Doe. It has to have an address. So it has to be the specific address, and it has to be a demand. And put your name, I, Mary Smith, I am the owner of this property, and you have no legal right to be here. Demand is made that you get out. And if you don't, I'm going to file an eviction. And so what happens is they'll get online and they'll go to Zillow or some kind of legal forms, and they'll send them a 5-day notice to pay. Well, you just gave them an offer to let them pay and stay and become your tenant. That's don't do that. Do not send a notice without talking to an attorney, because if it's a non-payment, hey, you don't have the right to be here because you haven't paid me rent. No, you don't have the right to be here because you don't have a lease.
Right.
So it's not that you haven't paid the rent. You don't have the right to be here, period. And then it needs a signature, and then it's got to be sent, right? How is it delivered? The law talks about taking something and putting it on the door. We call that posting. Some people call that hand delivery. It's not hand delivery. We have a whole statute that talks about hand delivery, and hand delivery is from one hand to another hand, and doors don't have fingers. So it's posted versus hand delivery. That's super important. That's a good idea, but it's not required. I like it because they're going to open and close that garage door or the front door, so at least they're on notice. But if you mail it certified mail, that's fine too. Under Title 12, there's no 5-day, there's no extra time required for mailing. It's just the notice to vacate. If they're not there in 5 straight days, straight calendar days, not weekend days. If they're not there, you can file on the 6th day without all the protections that are in all the other special detainer statutes.
So I have to say, I mean, I get that Arizona has landlord friendly, statutes, and, I guess 5 days is fast, but I'm shocked that if somebody's trespassing in your property, engaging in a criminal act, that they're entitled to any notice whatsoever.
I agree. And I can tell there's an argument, there's a case that basically says, if you're not out when I get to court, that's 5 days from when I know that you were still there. I don't have to give you a notice. The summons and complaint is the notice. That's a really crummy case. It doesn't explain the reasoning very well. And so what we do is we go to what are the judges trained to do, right? They have training manuals. I know that because I'm a judge, right? So I want to go to their training manuals. I want to see, what are they being taught to look for? What are their best practices? So each county has something different. So you're right. I think they should be arrested today. And you need to know, during the pandemic, our firm got a little creative about ours, because I'm like, if you broke in, we have this special statute, 33-13-68A, that says if you commit a crime, I'm going to evict you today. I'm going to give you notice saying what the crime was, but I'm going to file today. And I get to be in court in 3 days, not the regular 5 to 7 days. So I'm going to be in court in 3 days. And I'm going to have you served, and I don't have to get you personally served because you're here illegally. Now, all of that is under the Residential Landlord-Tenant Act, right? So it was a little bit of a jump for some judges to go, wait a second, you're saying they don't even have a lease. They're not covered by the Landlord-Tenant Act. I'm like, you're right, Judge. If people who are covered have this much protection, why should the guy who broke into Circle K, he's not going to get to spend the night for 5 days until you go to court, or in Walmart where the camping section is, we're going to have him arrested today. Why are you stealing my client's property and letting them stay? Because they're going to take the washer and the dryer and they're going to vandalize, do whatever they want. Why can't I be here? It's an immediate because it's a crime.
Right.
And I can tell you, we were very successful for lots and lots of cases. And a couple of judges were not very comfortable. I'm like, fine, then give them 5 days to move out. Because remember, an immediate, they have 24 hours to move out, 12 to 24 hours to move out. And I think once that became kind of more of a norm, I don't know if any other attorneys use that, but it became very, very regular for us. And we got quite a reputation of pushing that as hard as we could, as fast as we could. When we just started the process and we filed that eviction, there must have been some kind of website out there going, get out, because they weren't showing up to court. Before that, they were showing up to court with these fake leases and I thought fake stories. Because if you and I did that, I would have called the police immediately. I would have put a stop payment on the check. I would have contacted my bank and said, I've been conned. When you're not doing any of that, it seems like you might be part of that story or that con. And so we just got very, very aggressive, and we're still doing those today. We just aren't seeing very many. I would say we probably something like maybe 3 or 4, maybe even 5 a month. But when we really dig down into those, they're not what I call a true trespass kind of person. They're somebody who somebody else let them in. So I was moving. I'm your tenant. My cousin, John, just wanted to stay. He helped me move, and he wasn't quite out yet. Those cases, we don't treat them like a squatter. Right. We treat them like a landlord-tenant matter because that tenant hadn't turned over possession to us, and there are already established laws on how to address that.
So if what I'm hearing correctly, you basically, if somebody came to your firm there and they said, I came here yesterday, somebody's in there, I just need them out. Your firm, they probably would advise, we'll send the 5-day notice anyway, but let's file tomorrow and see, or today, and see if we can get a hearing in 3 days and get them out ASAP if we get them from, say, the right judge or can use this expedited procedure.
Exactly. So what we do is I say, okay, here's what I want you to do right now. You just filled out my new client form. Here's what I want you to do. I want you to call the police. I did. No, I want you to call and ask to speak to a supervisor. I want you to tell them you came home from vacation. You came back from take care of a sick family member. This is your second. You call them right now. If the police won't do anything, call the sheriff, because the sheriff, we have more than one governing authority, right? So do this first. While you're doing that at the same time, I'm going to email you this notice. Go and have the police deliver it at the same time. Also hand them a trespass notice, because we have 2 different versions, and let them know we're charging. We want to press charges for criminal trespass. Even if they don't remove them, you let them know I am being aggressive. I'm not going to sit back and give you a couple of weeks to figure it out. So we push that really hard on what we expect from you right now. And then if they don't leave, and some sophisticated people won't, especially if they've been running this con for a while, then we file that day or the next day, and we push the shortest court date we can. So typically the law says no less than 2, no more than 4. So we're right there that 3rd day. Courts set their own hearings on their own calendars because they have criminal and other stuff. So we still set it on their court regular docket, but then we come in prepared. So that we tell that owner, you get on that phone, you get on the computer, let the judge see your face. This other person looks all sad about what happened. No, you let the judge see you, that you are a taxpayer, and that this is your property. Don't just be too busy to call in or to let the judge know who you are. Make a difference and tell them your story. I brought up all the kids. We were here to spend our time in our Flagstaff house, and we get here and all these people are here and they're partying and they're damaging my property. And my neighbor said they're making all this noise, and I need your help, Judge. Help me right now.
Yeah,
And
if you're in a typical in a real life squatter situation in the type that you're defining, the average, not just the average, almost you can imagine any homeowner is so personally offended by what had happened. The thought that they wouldn't even make an appearance or show, you would think they'd be begging for that moment. Get me in front of that judge. We need to address this like last week, So
you'd be surprised. Their position is like, well, that's what I hired you for. I'm like, I am the legal mind telling this judge, and I'm your voice, but he or she needs to see your face. They need to hear the urgency. But if you're too busy because you're working and you're just too busy, then the judge is just too busy too. And remember, that makes a difference. That who's here, if it bleeds, it leads, right? We hear about in the news all the time. If it bleeds, it leads. Well, if you're not making a compassionate story, a compelling story, and the other person is, they can set it out for trial. A trial is going to be about a week away. And then depending on what type of occupancy, the judge may give them 5 days to move out. So they may be in your home for 3 or 4 weeks, maybe longer, because then the constable still has to come out there. So that's why we change the nature of why we file it, because it's getting them out much, much sooner. But we have to have all this information because, like I said, lots of times when I get the information, it's not what you and I would call really a trespasser.
Now, I know we're going to get into the eviction process here a little bit more. I'm just curious, though, one of the remedies that I've heard or ideas that I believe I've seen attempted in other states is the idea of giving law enforcement a little bit more direction on the front end of what they can and can't do to vet out cases, at least temporarily, to get the property owner back their property. Is that something that was considered by Arizona or that they've considered as maybe a solution?
Well, we already have, all the cities already have a law that's called a trespass law. You
Okay.
can sign it as a homeowner and say, no one's supposed to be here. So if you see somebody, especially if like a seasonal rental or not even a rental, seasonal home where you're going to be gone for 4 months, right? You tell local law enforcement, sign that order. If you see anybody on this property, arrest them. And then you have to give them an emergency number. They can call you and reach you 24/7. And so usually we give them a couple numbers, and that already exists. And so I can tell you that's the squatter law we were talking about, that got vetoed by the judge. That's really what was included. That what steps can the law enforcement do? What questions can they ask?
Mm.
And I think those were really created. We were all of us in our industry. We were part of creating that law because we wanted to assure the governor that this would not be used for any improper purpose, or if it was, it'd be a penalty. We built a penalty into that statute. If you're lying and you just really broke up with her and you don't want her to live there anymore, if you're lying, there's a very serious penalty for wrongfully ousting someone who was protected under some other landlord-tenant rights.
So, assuming after the notices, you got to jump forward to the eviction, break down what I'd like to hear two things. Break down the normal eviction process because there's two types of evictions, at least in my mind. There's the contested and the uncontested. And if you've been to court on these things, you'll see a lot of them just go uncontested. I'm assuming in this kind of scenario, there's a likelihood that it's going to be contested. In fact, a likelihood that somebody might even bring forward a fraudulent lease. So you're going to have to contend with a document out there that they say you signed that you didn't sign, so on and so forth. But what does that process look like, and how much time should they realistically expect the homeowner?
Okay, so for a typical regular eviction, we're in notice pleading state, so you have to cure whatever that notice is. If you don't, from the time it's filed until you're in court, in the justice courts is about a week. There are some smaller courts like in Tucson that can be longer just because of the way their court system works, but you're in court in about a week. And then from the day of court, that's called the initial appearance. And at the initial appearance, the judge can go right into trial if they have time, or if it's an immediate, they're required to, if it's an immediate, right at the same time, or they can set it out for trial. And that has to be no more than 3 days, court days, unless the parties agree. So that's what a typical one looks like. I would tell you that in most of our squatter cases, the true squatter cases, very few are contested, probably something like 10 or 15%. Because when they show up, we say, okay, judge, tell me their name, because I didn't know who they were. Can you have them show your driver's license right now if they're appearing? What's their driver's license number? Because I want to know, oh, you're John Smith with a date of birth. What's part of your, because I want to make sure that now we know who you are and that there's a record that you did this. And so as soon as you start that, as long as they just hang up, turn off they won't show up by camera. Very few who actually physically go to a courtroom. And those are ones that either are part of that con or really were conned. Those are more what I call the con category. But everybody else who really just broke in, it's like except there's a house over 2 streets over. I'm just going to go over to that one.
Okay.
So if it's set for trial, the judge will rule. Typically, those are 5 days. You have 5 days to move out, unless it's filed as an immediate. So the whole time, if it was done kind of typically, would be 3 weeks to maybe 5 weeks out. If it's done an immediate, you're looking at more like 7 to 8 days from when we file until the constable's locking that person out.
So just to summarize, it sounds like in the real squatter type case, the likelihood is that they're more likely using the process to buy time rather than seeing the process as an opportunity to go get the big win and win in court.
That is true. Now, let me tell you that some of the bad stories are the attorney who takes the case doesn't really understand the process, and so they'll do it like as a quiet title action. We just took one of those cases up, and 9 months, 10 months later, they're going, I don't think this seems right. Maybe they'll saw us in court, and then they'll come and call us. I'm like, holy cow, what in the world? No. And depending on what the other attorney has already done, they may have tied your hands on what some of your remedies are. But those are the bad cases where you have a sophisticated trespasser, a sophisticated squatter who comes up against an unsophisticated or unexperienced attorney, homeowner or an attorney, either way, but usually an attorney who doesn't have a lot of experience. And so they're telling you, hey, this case is going to cost you $5,000, $20,000. It's going to take 3 or 4 months, maybe a year. I look at that and go, no, that case shouldn't cost more than $1,000 at the most. And you should be completely done and have them locked out within how long? 2 weeks, 3 weeks, depending on where you are in that process and what court you have and how long it takes the constable about it. But if someone's telling you this is a big convoluted story, I'm very suspect of that, because unless whoever that occupant is really, really, truly a very, very sophisticated con artist. And I can tell they do come in, but they're not using the vacant homes. If you're not following kind of the trend, what they're doing is vacation rentals. So they come and pay up front for a vacation rental. This is the new scam, by the way, we're seeing. So your listeners should all pay attention to that. So we've got a lot of people who rent their home as a vacation rental because they're not there all the time. Well, then that person pays online on a credit card, and they could get in there. They're supposed to stay for, let's say, a week, 10 days, something. Near the end of their stay, they dispute the credit card. And so now they've paid nothing, and then they won't leave. And because we don't have very clear laws, is a vacation rental more like a hotel, an innkeeper, that I can lock them out, just like it would at a hotel? Or is it more like a landlord-tenant relationship? Those are problems. So if you're using a vacation rental site, like VRBO or Airbnb, there's no lease, there's no contract. So if you're renting your home as a vacation rental, you need a contract that says this is not a landlord-tenant relationship. This is an innkeeper relationship. If your money, if you do these things, your money is invalidated, it's an SF, whatever, dishonored in any reason. If you do these certain type of things, I can come and lock you out. And then that's a separate set of laws. And so until our state changes it and makes a vacation rental clearly something, its own animal with its own laws, I tell everybody, write a contract, not a lease, but a stay agreement that says this is what I can do. Because when you're there to do the lockout and it's the con, because that's what, like I said, our new con is, and like, no, I am here. They have to go to court to get me out at this $7,000 a week rental. Those are people who are very good at this scam, and they're going from vacation rental to vacation rental. If you have a good contract, you could go and lock them out by the time they come, because you're not calling the police. You just wait till they leave. Change the code, change the lock, remove their possessions. The innkeeper has a separate set of laws on what you do with their stuff. When they call the police and say, I'm supposed to be here, and they go, well, show me your driver's license. Well, it's a vacation rental. Oh, sorry, it's a vacation rental. There's nothing I can do. So they're not that good at helping you get the person out of the vacation rental. But if you wait until they actually leave, and vacation rentals are a little bit different, right? Can you turn off the utilities? Probably, because it's not a landlord-tenant case. So there's all kinds of things you can do that would help you get someone out of vacation rental faster. But start with a better contract.
have you seen sophisticated scam artists who actually do their due diligence and figure out who owns the property? And then, of course, a lease doesn't have to be notarized. And they create their own lease and they purport, they basically sign or forge the owner's signature, but it looks like it's a valid lease with the named homeowner. Have you seen those scenarios?
Yes. Yeah. Not as prolific as you see on the news, but yes,
Right.
where they'll have a check. They'll have a bunch of checks
Yeah.
that are allegedly all cashed. That's our job. We go in, become like forensic analysts and go, well, let's turn it over. We've got someone in our firm who's kind of a banking expert who can say, well,
Mhm.
this code, my client's account is Chase. This is not a code that was cashed in Chase Bank.
Mm.
So there's a number of things. We look at the handwriting samples and we can lift off layers of when things were signed. And we look for the email addresses and, we'll look for very sophisticated things to pull those cases apart. And my experience is even the really, really good con artists, when we're in court at the trial and telling a really good story and we're just catching them time after time, like we're recording this and we're going to prosecute, we're going to use this particular evidence, and their testimony, sworn testimony, they have the right to remain silent. They don't have the ability to, but they have the right to. We take that and now we use that to press charges too.
Mm.
And usually when you're pushing that hard, they're going to go, okay, I'm going to go find somebody else. But what we're found probably in the last 8 or 9 months is a much larger percentage of them are much more sophisticated. So of the ones, we don't see them very often, but when we do, they tend to be more sophisticated and they tend to be some of the higher end properties because they can have a really nice vacation for months. And we don't really even know their names because they have multiple aliases and multiple driver's license and all those things.
Now, you mentioned a notice you can provide to law enforcement. And I believe Arizona has something that you can record or file with the county to protect against like a what they call deed theft or deed fraud.
Yeah.
Is there something similar that you can do, to protect your, property from squatters, where you file something with the county or somewhere that basically says, hey, look, I'm not renting this right now, type of thing?
That's a good, I can tell you that's a good thought process because we're using those for the title fraud. I just don't think that they would be relevant in an eviction trial because you already have an owner saying, I didn't sign that. It doesn't matter if I went the extra steps and I recorded that. But would that be an additional, log to build this house? Yes. But I don't know that you'd need to spend that because it's probably going to be difficult for you to then take that off or to explain it at the time you're trying to sell it or rent it. The better preemptive things are, putting an alarm system on, putting the stuff inside the house saying, hey, don't rent it if it's not from this particular site, watching your water bills, having some kind of alert on that. Some people actually even do a Google alert. They put a Google alert on their name. And so if a lease comes out, or let's say it's something on Zillow, I'm picking on Zillow today, but they're just, a lot of people are using those now because they think it's a good, cheap way of renting. I think it's a terrible way because you're not doing any kind of real background checks. They don't ask the right questions. But let's say that if it comes up on Zillow, you're going to get a Google alert that there's a rental, there's some document in the public domain that has your name on it. And so you would be alerted very quickly that there's something out there. And you would tell Google, hey, that's not mine. You would tell, whatever that social media outlet is and say, that's not my ad. And be able to get that down very, very quickly.
It sounds like the bottom line and the one of the biggest things you can do as a homeowner or investor is just not advertise that you're away in any way if you can avoid it.
What do my parents say? Loose lips sink ships,
Yeah.
right? Back from the baby boomer era, and that's exactly right. We live in a world of social media and everybody posts, hey, we're going to France. We're going to be gone for 3 weeks. We're leaving on Thursday. And, oh, look, we're here. And so I think that by not paying attention to what you're telling the whole entire world, because it's so easy to find you, especially bad guys are easy to find you, that's really the idea. Think about what you're posting. Think about what you're telling. If you're going to be gone, it's nice you have the lights on and off and some of the neighbors, but think about having an alarm system, and they're so inexpensive now. and they don't have to necessarily even all have to have Wi-Fi service all the time. So it's just a lot of things that you can do that just say, you go do it somewhere else. Just don't come here. It's like having a large dog that's barking. It's less likely you're going to be burglarized than the house that has a cat, right? That doesn't have anything that's going to say, hey, this person looks like they may want to stop you.
One other thing, when you were explaining earlier, lawyers sometimes making these cases more complex than they have to be sometimes, and charging extensive fees to do some of this stuff. Oftentimes that's because the law office isn't equipped to do, landlord tenant in any sort of volume, whereas like your office would be. I can tell you right now, our office is not equipped to do it in any sort of volume, and it ends up costing more money. But the reality is, if you get the wrong lawyer who sets this up wrong, the judges usually, at least in my experience in justice courts, aren't inclined to even award attorneys fees in big numbers, even if you're entitled to them. So it seems to me it's even more important to make sure you get a firm that knows what they're doing, isn't going to charge more than the court might award you back.
And it's a good question. You say, okay, how many of these have you done? Well, you'll be our first. Okay, I'm having heart surgery. How many have you done? If you haven't done 1,000, and that sounds like a huge number. If you haven't done 1,000, you just don't have the experience. You haven't seen all the bad things that can happen, right? Anybody can do 1 or 2 or 5. But when you start getting in those high hundreds, just the more you do it, this particular judge has the court on this particular day at this particular time. So when we're filling out the summons complaint, we ask for that time. So we preset it because I know that's the time. I don't have to wait for them to pick a time for me that might be a week later. I know the fastest time. We already have process servers who are here multiple times a day that are doing those runs. And so I don't have to worry about getting the right kind of language in the affidavit. That's a way to get the case dismissed. I don't have to worry about having the wrong kind of language in the summons. The Supreme Court just passed or adopted a rule or partially adopted a rule that changed part of a special notice that we give in residential evictions. It's like a mini Miranda right. They just changed that. So if you don't do this for a living, you wouldn't even know that changed. So you don't even have the new copy. So your process server's not going to have the new copy, but all the judges are going to be watching of that, and they're going to dismiss the case if you don't have that new that new notice. We call it the REIS notice, REIS notice. So that's why you need somebody who's doing a lot of those, because we know what the judge is going to throw out and what the judge is going to require. And if you had to start all over again, you've already now been weeks. Now you're starting all over again.
Yeah. Nothing more frustrating in a landlord-tenant case than having it dismissed and starting over. Speaking from experience, so we've seen it. Denise, thanks so much for being with us. This has been great information. Tell our listeners how they can find and connect with you.
So we are Holliday and Holliday. I'm Denise Holliday. Our phone number is 602-230-0088. Our website is the letter H, as in Hull, Holliday, and Holliday. So H3, landlordlaw.com or drvictorl.com. And we'd love to hear from you if you have any kind of need. We've got it right on our website. A real simple way for you just to fill out a new client form. We ask lots of important questions so that we can screen it carefully and quickly to make sure that we're doing the right thing and not asking the 30 questions that sometimes get the wrong answer. And you're like, well, if I had known that, we would have led with that. And so we'd love to hear from you if we can help. And thanks, you guys, for having me on. That was very nice. It's nice when law firms can understand what do you do great and what is somebody else, what do you send on to that other firm, because that's something that they're more specialized in or focused on.
Yeah, for sure. Well, it's been great information. We appreciate you being with us. Let's do it again soon sometime.
Sounds great. Thanks, guys.
All right, Denise Holliday, everybody. With that is our show. Make sure to join us next week. We'll see you then.
Have a good day, everyone.